Yes, be ready. Start. No such sale could have been won in the course of import because the sale did not occasion the import stop. None of those was export because the goods were not supposed to enter into the territory of another country in the form those were dispatched. Stop. The analogy of sales from duty free shops was irrelevant. Stop. For it always remains on the other side customs frontier, and so the risk is transferred before crossing of the frontier. Stop. Thus there was no gainsay that sales of goods to masters of ships were sales in the state and were taxable. Stop. The dealer was asked to pay tax on such sales and revise the return for the years yet to be assessed. Stop. The assessing authority was requested to revise if necessary assessments not impugned. Stop. The appellate and revisional authorities were requested to treat the tax payable on such sale as admitted one. Stop. Feeling aggrieved, the appellants resorted to revision before the tribunal, which came to be rejected following the decision of the tribunal passed on the same date. In case of the companion appeal. Stop. The appellant carried the matter by way of a writ petition being number 6 oblique 2007 before the High Court, which came to be dismissed by the High Court, uploading the decision of the authority which had held that the sales in question would be amenable to sales tax under the 1994 Act. Stop. New para. The thrust of the argument of the appellants in these appeals is that the process of import was not complete at the time of sale of the goods in question to the foreign going ship, and transaction of sale was in the course of import, for which reason it was not amenable to sales tax, and in fact the state would have no authority to levy such tax. Stop. To buttress this submission, reliance was placed on Article 286 of the Constitution of India, providing for restrictions as to imposition of tax on the sale or purchase of goods, and on Section 5 of the CST tax, in particular subsection within bracket 2 thereof, to contend that the sales in question shall be deemed to have taken place in the course of import of goods in the territory of India. Stop. Reliance was placed on the Constitution bench decision of this court in J.V. Gokal and Company Limited versus Assistant Collector of Sales Tax. Stop. Over.